Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open. 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Jim Potts back on the air. Well, look, here we go again. You know, over the years that I've done this podcast or even the blog, and I know you've heard me talk about disability discrimination in California, and I've told you what a trap it is, what a hazard it is for employers to be careful about regarding potential liability. And I know for some of you saying, oh no, he's not talking about this again. Well, let me just tell you why I'm talking about it. Because now, as usual, there's another fly in the ointment, as they say, with disability discrimination in California. And basically is what it has to do with is whether or not an employee who gets terminated based upon a disability of a family member. So I'm going to go through this with you, to give you some facts on that in terms of what happened. So listen to this. As a matter of fact, this hit the Court of Appeals, and it has to do with whether or not that the employee had a claim for disability discrimination against his employer, even though the employee himself was not disabled. Instead, the employee's son was disabled with a kidney condition that required daily dialysis treatments. Now, basically, is what the employee did was that he requested that the employer give him an accommodation because he had the expertise and skill that he had learned to be able to give his son dialysis, but he had to give him the dialysis in the late afternoon. So basically, the employer initially gave him an accommodation where he could work the earlier hours, and at the end of his 8-hour shift, he gets to go home and he would be able to give his son the dialysis treatments. So the employer provided this accommodation for him. But here's what happened. A new manager comes on board. The new manager comes on board, and now the new manager gives this individual the late shift, or a later shift, I should say, that now encompasses the time whereby that he needed to be able to give his son dialysis. Now, you may look at that on the face of that and say, look, was this due to the requirements of the company? And I get that. Employers have a right to set schedules out, and I get that. But you've also got to be smart enough to understand that when you're dealing with a disability, now in this particular case, the employer didn't look at this guy and say he had the disability, it's the son's disability. Look, I'll say it again, it's California. The Fair Employment and Housing Act has stricter guidelines than some of the guidelines on a federal basis. And I try to get employers and managers to understand that the word disability jumps up, it's got to be a red flag. Now, here's what happened. The employee sued the company for disability discrimination, failure to accommodate, failure to prevent discrimination, and other related claims under California law. Now, the trial court actually granted summary judgment to the employer. Why? Because the employee was not the one with the disability. All right. Now, the Fair Employment and Housing Act accommodation requirement provides that an employer must reasonably accommodate the needs of the employee with disability. So that's why the trial court initially threw it out. Now, because I'll tell you that their reasoning, they held that the discrimination-based claim similarly failed because there was no evidence that the employer terminated employees' employment based on some discriminatory action, based on the fact that he had a disabled son. Instead, the evidence showed that the employer terminated the employee's employment because he refused to work his assigned shift, not because it had anything to do with the disability itself, but simply he refused to work the new shift. And that's why he got fired. according to the trial court. So, with that in mind, the plaintiff appealed the adverse ruling as to the disability discrimination, failure to prevent discrimination, retaliation, and wrongful termination. He abandoned his failure to accommodate claim because, again, it went back to him, not about the employee. Now what happened was that the Court of Appeals got the case because, as I just stated, the plaintiff appealed. Plaintiff is the one that's bringing the action. So they issued a decision and they reversed the trial court's ruling. Their logic was that an employer has a duty to reasonably accommodate an employee who is associated with a disabled person. Associated with a disabled person. And two, that California recognizes a claim for disability discrimination association. All right? Now, the Court of Appeals further held that the plaintiff was entitled to a trial in the claim because, as I told you earlier, the claim had gotten thrown out. And I gave you the court's logic for that. So now is what happened is the employer appealed that decision. Now, here's what's going on. The court did go so far as to suggest that the term disabled within the meanings of the Fair Employment and Housing Act includes employees now who are associated with a disabled person. Now, what does that mean? That means, once again, it's going to open up the doors to litigation that if a person has an issue with a disabled family member, that if the employer does not provide some kind of accommodation for them with that's going to once again create a nightmare. So now employers already have to deal with employees that may have a disability, whether that disability is work-related or non-work-related. Now they've got to deal with a family member that's got a disability, and the employer is going to have to make a basic accommodation here. Now look, some people may argue that that's not a bad thing. We keep getting away from the fact that employers have businesses to run. They've got to have employees there in order for them to work. It's not always about somebody being insensitive. Sometimes it's just simply, I need to have people, there to do the job. These laws are in place for a reason, and I get that. Now, the Court of Appeals also held that regardless of whether or not employers have a duty to accommodate an employee who is associated with a disabled person, California recognizes a claim for these types of claims for disability associated with a family member, meaning that employers cannot discriminate against an employee for having a disabled family member. The court held that the plaintiff had presented sufficient evidence to support a finding of this type of discrimination. Specifically, the employee presented evidence that despite expressly informing his new supervisor of his need to be home in the evening, his supervisor scheduled him to a shift that started at noon, later than he had ever been scheduled to work before. Now you look at that and say, okay, what's up with the new supervisor? Did the supervisor not be aware of this? The supervisor was trying to set up his own schedule. However, listen to this. The supervisor did this even though he had scheduled at least 8 other drivers. So this guy was a driver. He had scheduled 8 other drivers for earlier shifts that day and then lied to the plaintiff about the reason for denying plaintiff an early shift. The supervisor told the plaintiff that a customer had complained about plaintiff's service, and that was the reason the plaintiff was being taken off that early route. This was false. It was a lie. So why did he do what he did? I don't know whether the supervisor didn't like this guy or whatever or whatever the case may be. But think about it logically out there, managers and supervisors. If this guy had already been on this schedule, he's a driver. You've got other drivers that you're working with. Use some common sense with some of this. This particular supervisor cost this company money because he wouldn't give this gentleman an accommodation, when in fact, the earlier shifts he scheduled for other people. If this guy had already been on that earlier shift, why would you change that? All he did was open up the door for litigation for the employer. And now the employer is looking at paying whatever the heavy penalties will be for something like that, because it's going to end up going before a jury now. And when it gets in front of a jury, who knows what could happen? Punitive damages can be astronomical as a result of something like this. So you've got to use some common sense out there, managers, with this. Now, because of the evidence, because he spoke in a false way, The evidence could support a finding if it goes to the court. So that's why the appeals court saying that now it can proceed to trial. They could support a finding that the supervisor simply did not want to deal with the employee's distraction associated with having a family member that's disabled. So for those reasons, the Court of Appeals held that the plaintiff's claim should not have been dismissed by the trial court and that the plaintiff was entitled to have a jury decide the claims. So there it is. Now, there was one of the justices did not agree, but it's what they call a dissenting opinion, arguing that the majority opinion is wrong and that the trial court properly granted summary judgment. But I will tell you that you can expect that this case is going to head for a further petition before the California Supreme Court. But in the meantime, employers, I need to tell you, okay, that for the time being, because California may go in this direction, you might want to think about giving them an obligation on the reasonable accommodation when it in fact involves a disabled family member as well. Because it's easier to do that than to end up in court. And please use common sense with some of this. This is a circumstance where the employer should use common sense along with the supervisor. And even if he had recommended termination, somebody should have stopped him and said, wait a second, this doesn't make sense. Okay, before I end this segment, I'd like to say that Thanksgiving, I know, is coming up very shortly. As I had told you, a few weeks ago, with these holidays, please be safe out there. Watch the drinking. Watch others who may be drinking, because it's always smart to watch out for the other person as well. All right? So have a happy Thanksgiving for those of you that do celebrate Thanksgiving. And for those of you who do not, hey, happy whatever it is that you do celebrate. Fair enough? All right, with that last comment, it's time to close out this segment. But let me remind you, you can also hear us on Facebook at Listen Up and subscribe to us on iTunes. Just look for Listen Up with Jim Potts. As a reminder, we take calls every third Friday. We can be reached at 855-4J-POTS or 855-457-6887. Or you can email us at jameswilliampottsllc.com. Okay, I'm Jim Potts. I will continue to fight the fight, and thanks for listening.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@jameswilliampottsllc.com. Until next time, make it a great week.